Deputy Chief Warren Brown.
Whoa.
I did nothing.
Whoa.
I did nothing.
Right here. Stay right here.
I did nothing. What did I do?
Stay right here.
I left 2 notes. One for the
Face me. Face me. And don't ever do that again.
I left a piece of paper.
Ever do that again.
It's a piece of paper.
If you come out, you walk to that podium. Am I understood? Am I understood?
Okay, pause right there. Did you catch that power shift? The judge lays down the ground rules fast. Face me, don't ever do that again, am I understood? That's courtroom control 101. In legal terms, this is about maintaining order and authority because once a defendant starts freelancing in a courtroom, everything spirals. But here's the bigger issue. The public defender immediately flags competency. When someone is declared incompetent, that means they may not fully understand the proceedings or be able to assist in their own defense, a constitutional requirement under due process. So now we're not just dealing with attitude, we're dealing with mental fitness to stand trial. Do you think the judge handled that firmly but fairly? Or did it escalate too quickly? Buckle up. This courtroom is just getting warmed up.
Guess one.
Go ahead, counsel.
Warren Brown, Deputy Chief Public Defender, being written on behalf of Mr. Amit Ehrenreich. Please state your name for the record.
To ensure justice is made, I will make 5 brief statements and then state my name.
No,
Dana
you will
from the
state
forensic
your
center
name. You
had
will
first
state
met me
your name.
Of July 20.
Take him back.
Yet,
Take him back.
7 months
Because take him back. He'll follow the rules or not. Have a good day. We may call you back. We may not. Okay.
So, Your Honor, for the record,
For the record, what?
Mr. Ehrenreich remains incompetent, but I guess that.
Yeah, I know. And I think he technically has to be here. I don't know that he's forfeited the right. Ms. Hughes, are you okay?
Sorry, I'm embarrassed. I'm sorry.
No, why embarrassed? What are you embarrassed about?
Sorry, I'm totally fine. I'm just overwhelmed. I'm really sorry.
Okay, no, go ahead. She shouldn't be embarrassed by it. Okay, so we all have to be real. Had that been Blanche, he would have been punched. So I'm just saying. I mean, guy would have been tagged out, he'd be down.
Are we going to just pass this and then we'll come back later?
I'm sorry, I didn't hear you.
Your name.
Tariq Samar, Tariq Ade.
Okay. All right. What are we doing on this case?
Oh, I'm still waiting for the hearing for the jurisdiction hearing. I put in
For what?
the jurisdiction hearing, put in a motion for dismissal for lack of jurisdiction.
When did you put that motion in?
It's been, I'm not sure when it was.
Did you
filed.
file a written motion?
Yes. I didn't get a receipt or anything. It said they filed it and or at some time.
Have the people received a copy of a motion regarding jurisdiction?
No, in May, the last time a different prosecutor and Your Honor and everybody else was here, there was conversation on the record about the defendant having filed a motion. We're still waiting for the defendant.
Competency. I don't have a competency report.
There's a quote we'd like to quote, Your Honor, in our files. And the quote is about how we will not be addressing this until the competency report is back.
Thank you.
And then it would have to go through his counsel.
And the other thing, okay, so that your counsel, I will give you an opportunity to look at it because I don't know what to make of it. He sent something to the court. Like an attempted to draw a check on the back of a birth certificate and then some notice of adequate assurance for performance and settlement. Whatever. So we will give counsel an opportunity to look at that. I will adjourn this matter out for competency. I was giving what date? October.
Talk to.
October 20th.
They said that the competency hearing was on the 25th. I wasn't given any other information after that.
Say it again.
And I tried to ask him at the last hearing, he said it'd be coming in the mail.
And October 24th, 2024, 9 a.m. If we get a report prior to then I'll move the date up.
Thank you, Your Honor. So,
Thank you. Counsel, we will let you look at that. Maybe we can, what we'll do is we'll just make copies of it,
thank you.
send it to you.
So what has happened is.
Thank you. Sir, in the lines, what's your name?
Austin Douglas Smith.
Are you on the docket?
That's my attorney right there. She said I was at 9, but now I'm at 11.
Okay, you're at 11?
Yeah, I was trying.
All right, I'm getting messages that you're causing problems in our hallway out there.
Oh, I'm sorry. I didn't even know. Was I doing wrong?
Pardon?
Sorry, I didn't know what I was doing wrong. Sorry, Your Honor. I thought it was a court case that I was on. I didn't know what I was doing wrong. I was listening to music.
Okay, I don't want any trouble. Anybody tells you to do something, you better follow their instructions. Otherwise, we're gonna have a real difficult time at 11.
Yes, sir. 11. So you want me to come back in or stay in here?
Wherever you're gonna behave, you can stay. Got it?
Yes, sir.
Thank you. Court is standing recess.
All right.
That you operated an unregistered vehicle. You understand that?
Yes, sir.
That's a misdemeanor, also punishable by up to 90 days, a $100 fine plus court costs. You understand that, sir? Yes?
Yes, sir.
All right. First question I have for you is, do you want to be represented by an attorney?
I'm sorry.
Do you want to be represented by an attorney?
No, sir.
Okay, so what are you going to do in this case?
I was looking to dismiss both of them.
Yeah, I'm sure you were.
And there it is, the fastest legal U-turn of the day. She starts off confident. No, sir. No attorney needed. 2 minutes later, yes, sir. Let's break this down. The Sixth Amendment guarantees the right to counsel, but defendants can waive it if they truly understand what they're doing. The judge's line of questioning? That wasn't random. He was testing whether she grasped the seriousness of a misdemeanor carrying up to 90 days in jail. When she says her mom might help dismiss the case, that's the red flag. Court is not family court advice hour. And the subtle humor here actually serves a purpose. It nudges her toward protecting herself legally. Question for you. Should judges step in like this when someone clearly doesn't understand the stakes? Or should they let people learn the hard way? Because that one yes, sir, may have just saved her from a disaster.
Do you think that's going to happen?
I'm not sure.
Who might know how that might happen?
My mom? I don't.
So, how old are you, young lady?
21.
You in school?
Yes.
Where? I teach there, so I know they're a lot smarter than me right now. So, my question, you want the case dismissed,
Yes.
right?
Sir.
So, who might assist you if that is a possible option in getting it dismissed?
You?
I'm not here to assist anybody.
Oh, attorney?
Oh, wow. I know. Get out. So I now will ask you the question again. Do you wish to be represented by an attorney?
Yes, sir.
Okay, there we go. See, that's washed enough. All right. This is a public defender case.
Assistant Public Defender Natalie Pateworth, and on behalf of Ms. Gray, Your Honor, we would waive any further reading of the complaint, stand mute as my client, or ask for pre-trial date and a PR bond, Your Honor.
Defendant having waived from a reading, standing mute, court will enter a not guilty plea. First thing I'll do is pre-trial will be set. There's what day?
August 7th.
To August 7th, 2024. 9 a.m. That's the bond in this case. I can set the bond. I'll get the file. I'll set her bond at a $5,000 person over cognizance bond. I'll order standard conditions, including no assaultive behavior or possession of any weapons. There's to be no use of any alcohol, recreational marijuana, or any illegal drugs. You understand that?
Yes, sir.
All right. And young lady, what are you studying to be?
Major in sports management, minor in physical therapist.
Ah, really? That's what you really want to be when you grow up?
Yes,
Really?
I love sports.
So why you want to do all that? You can just first till you need to about.
Cause I break too many bones. So why not be a physical
What kind of
therapist?
sport are you playing?
Basketball.
And breaking bones?
Yes, I broke my hip, my pinky. I get physical. You gotta get physical on the court.
I get it. So you broke all that.
Yeah,
What position?
a point guard, shooting guard.
How are you a guard breaking up? Never mind.
When you
No,
drive,
I don't
center-
even want.
When you drive, there's like 6-foot girls. I gotta get to the basket.
Okay, I mean I get that. On a pinky.
Yeah.
Wow. All right. Just mark the file. Our little guard. That's what we'll. All right. We'll see you on August 7th. Who's that with you?
My mom.
Did you really break all that? Wow, causing the family problems because you're breaking bones.
Yeah.
Were the points worth it?
Yeah.
Yeah, darn right they were. Okay. Okay, take care.
Thank you.
Do you admit responsibility to the fact that on or about June 16, 2024, Clark Road, Pittsfield Township, Washington County, State of Michigan, that you double parked a motor vehicle?
Yes,
All right, court will accept that admission to count 2. Count 1 is dismissed. Fines and cost of $180. When can you pay that?
I'm on a fixed income right now, so I won't have any money until August the 3rd, and I'll try to pay it before then.
All right.
Your Honor, I am so sorry. I admit my foot just slipped off the paddle. I was already, stopped at the light in front of the car, and I looked down because my boyfriend was in the hospital, and I'm trying to sneak up there in his vehicle, unknowing where I'm at. I've never been to Ypsilanti in my life, and I was just trying to get up there to surprise him for Father's Day. However, my foot slipped. I'm not used to driving his vehicle, but I did that day because he left it in my presence. So I do admit that I did barely even bang this man's car. I was crying. I was upset. I was truly upset.
And Ms. Runner?
Yes.
Okay, I believe you on all of that. Ma'am,
Thank
you receive SSI?
Yes, sir.
Okay, and how much is that a month, ma'am?
117 a month, 1,017 a month. But I also have my lights, gas, my phone bill, my groceries, all of that to buy everything, and I'm just battling cancer, pancreatic cancer. I made it through by the grace of God. Have mercy, Lord. Thank you. But, Your Honor, I'm truly sorry.
All right, Ms.
I've never
Runner.
been in a car accident before in my life.
Okay, Ms. Runner,
Yes.
here's what I'm gonna do. Fines and costs of $180. I'm gonna waive that entire balance, ma'am.
Thank
go
you.
and take it. All right, you take care of yourself, Ms. Runner.
Thank you so much. God
You're
bless
welcome.
everybody in the courtroom today. Have mercy, because I'm so sorry. I didn't mean to slip off the brake.
I know, Ms. Runner, I've been
Yes.
doing this a while, and I can just hear, even though I can't see you, I can hear it in your voice.
I'm
It shouldn't
sorry.
have gone this way.
Yes.
It's okay.
Yes.
All right,
You
you
know,
take care of yourself.
Yes. Thank you, Judge. Thank you, Your Honor. God
Thank
bless
you.
you. Thank you. And it'll never happen again. Thank you.
I'm sure it won't, Ms. Runner.
I'm terribly
All right.
sorry. God
Yes,
bless
ma'am.
you. even for wasting your time. I'm
You
sorry.
didn't waste our time. You brought joy to our day. Okay?
Oh, God.
So
Thank you.
you take care.
Thank you so much, and you all too. God bless you. Thank you, Your Honor. Oh, God. Thank you.
Good morning, Your Honor. I'm Alex Parks on behalf of Mr. Dink.
We got that this time. Okay, go ahead.
Your Honor, we were finally able to reach Mr. Dinkins last night, only to find out that he's been in the hospital since Tuesday because of the defibrillator in his chest went off and shocked him. He's having a procedure today. We are able to get the court documentation of his hospital stay, and in this matter, we are requesting an adjournment.
Hold it. We have the documentation.
We are able to get you the court documentation very quickly. We found out last night from him. It took us a long time to get in contact with him.
Okay, I'm trying to figure out what you're trying to tell me.
So we're requesting a short adjournment. There has been a plea offer in this case that our client is ready to accept. And if we could come back in 2 weeks, we would do that then.
Okay, but you don't have the documentation.
We do not have the documentation.
You're going to get it to me.
Yes.
So what you meant to say is you're going to get it to me. You can get it to us quickly.
Yes, we can get the
Okay,
documentation.
that's
quickly.
Thank you. Probable cause conference will be adjourned August 1st, 2024. 9 a.m. bond continued.
Thank you, Your Honor.
And young lady, do me a favor.
Yes.
All right. When you come up, you're doing just fine. Just take a deep breath. All right. And just say what you have to say. All right.
Yes, sounds good. Thank you, Your Honor.
Oh, boy. Here we go.
Good morning, Your Honor. Maisie Berger requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Mr. Jay Bellinger, representing my client, Ronald Fleming.
Wow. Impressive.
I memorized it for you.
I know. Hey, that's what happens.
I threw away the card.
There you go. You don't need them. Permission to practice is granted.
Thank you, Your Honor.
As to bond.
Your Honor, we are just looking to address the condition of bond that requires that Mr. Hopkins be on house arrest. Prior to this matter, Mr. Hopkins was employed as a result of having the tether plate. No longer able to, in this case, he was no longer able to maintain that employment. He is hoping to be able to get new employment and is asking that the court consider a no go-to order, a no contact order, or anything of that nature. My client, Mr. Hopkins, also recently registered for the cybersecurity program. Text me that information. I tried to send the confirmation to Ms. Barroso so that she would be able to see it. It's my understanding that the classes are majority online, but that would be the only place that he would have to come across Washtenaw County. Otherwise, he's just asking for some order that would allow him to work and just not have that kind of contact.
Response.
Your Honor, the bond in this case was set at $5,000 cash or surety when we requested a $50,000 bond. In this case, the people are uncomfortable with him being out. This was an event for a series of events that occurred where the defendant assaulted the victim at not one but two locations. An eyewitness saw the defendant shove the victim while near the police station. The police attempted to make contact with the defendant, and then he picked up, as a result of him resisting, picked up 5 counts of R&O against 4 different officers. One of those 5 counts is an R&O causing injury that was so severe that the officer is actually seeking specialized medical treatment from an orthopedic surgeon. At this point, this is a 9.
So hold on. There was a DV and then an officer injured. Why is he out?
Your Honor, if I could address.
Hold on. I'll let Ms. Barroso finish and then you can address it. I just had an intermediate question. Go ahead.
So at this point, I don't think that a modification of bond removing him from being on house arrest is appropriate. We objected to a nominal bond of $5,000 when it was originally granted. At this point, I don't think that any further reduction is appropriate.
A couple of things. First of all, Mr. Hopkins is here with his father. He is 20 years old. He has no prior criminal history. In reviewing the police report and the video, even the report references that the altercation, that the incidents that resulted in this charge, that there were,
In which
that it was,
charge?
I'll start with the domestic violence. That with those charges, that that there was a more complicated situation. I believe the officer said, the report says something to the effect of, and this would also go to the property, that there had been physical altercations between the two of them, fighting between the two of them, and breaking of objects between the two of them. So I believe that there's more to this than said. The allegations of the domestic violence are the one of the shoving, and also I believe of Mr. Hopkins taking his own computer back from the complainant. That's the second allegation of the domestic violence. And the resisting and obstructing is, the allegations are that Mr. Hopkins, not that Mr. Hopkins turned around and slammed someone or punched them or anything, that he pulled away. The allegation is the officer fell and that caused the injury. And then that officer fell, yes, as he pulled away. And then subsequently, 4 officers who were, some of whom just pulled up on the scene in the video, all ran after him. And that's where the resisting and obstructing comes. And he did, in fact, eventually stop. It was not, it's not as if he were in a vehicle and went miles or hours away. He did stop running, and he did, once they complied, once that occurred, there were no further incidents. So.
Your Honor, I'm sorry, that is not the characterization of the RNO. The allegations include him punching 2 officers in the face, breaking free of their grasp, causing them to fall to the ground, twisting and seriously injuring an officer's finger. And then it went on for such a period of time that an officer had to point and deploy a taser. And that another officer had to point their pistol at a defendant. So at the defendant. So at this point, I don't think it was him passively.
Your Honor, I had an opportunity to view the video.
Well, you had an opportunity to view the video.
Yes,
sir. Let me ask you this. Was a taser deployed?
Your Honor, when
that's either yes or no. Was a taser deployed?
Your Honor, as soon as the officer saw him, she pointed the taser at him. This is not, as soon as she saw him, she pointed the taser at him. This is not a situation where he was running and pointed the taser.
I didn't ask that, Ms. Gaines. I did not ask that.
Yes, sir.
Was the taser deployed?
Yes, it was.
Did an officer have to draw their weapon?
I did not see that. I could not see that on the video.
Ms. Barroso, are you indicating an officer had to draw their weapon?
That is what was indicated to me in the file, Your Honor. Yes.
And then there's an officer that's injured. Again, we'll ask the question. I don't know why this individual's out.
Again, Your Honor, he's 20 years old. He has no prior history, and he has no reason to come back to Washtenaw County other than for school in this case. It's my understanding. I have not heard any information that he has had any contact with the complainant, has violated any orders. He is just asking to be able to go to work and to be able to get a job and go to work. Your Honor, would you want to hear from Mr. Hopkins' father who's present?
I don't know what he could tell me at this point in time. I'm more worried about the bond as it originally is set. I don't. Does he have prior convictions for anything?
No, Your Honor.
That the original domestic was about. I mean, I'm trying to figure out, because I'll just tell you, I have some serious concerns that this escalated to a point that officers are having to deploy a taser, pull their weapon, and there are clearly enough officers around to, in my opinion, have subdued this individual without having to do all of that. So something else is going on. And
Your Honor,
I also have, I mean, one's bad enough, but I have 2 counts of domestic violence.
again, Your Honor, one of them is him taking back his own computer. That's one of the allegations. And that's why I'm saying there were things that were happening before this. That's not to excuse his behavior. That is to say that there's broader context. And in my view of the video, initially there was 1 officer, then there were 2, and he ran from 2, but as he's running from those 2, there are cars, 4 and 5 cars are pulling up with sirens on an unarmed young man who clearly panicked. This is not someone who's had police involvement, who has a history of contact with law enforcement and the criminal justice system. Again, I'm not excusing, but I do think that there is there's more. I think there are more nuances to this than the prosecutor does.
Well, explain some of those then. Because I've got a victim of a DV that's injured.
She is not, the domestic violence person is not injured. It was the shove and the taking of there's no injury to her.
Domestic violence are 2 misdemeanor counts.
That is
Felonies
correct.
here are 5 counts of
Yeah, I see that.
Are no causing injury.
Maybe I misread that on the report, but
Yes.
the injury to the finger that's the officer.
That's correct.
Thank you. I don't understand this. I mean, there's a lot I don't understand. How, and I get there are resisting and obstructings that are filed that some may look at as questionable in terms of the charge. I get that. But I'm also trying to figure out how an officer gets injured.
Wow, this is where the tone shifts from light courtroom moments to real consequences. 5 counts of resisting and obstructing, allegations of punches to officers, a taser deployed, a weapon drawn, and an injured officer seeking orthopedic treatment. That's not minor chaos, that's felony-level escalation. Now here's the legal chess move. Bond isn't about guilt, it's about risk, flight risk, danger to the community. The judge openly says, of rights, I should raise his bond. That's judicial language for, you're lucky today. But instead, he holds the line and kicks it to the next judge after preliminary examination, where evidence gets tested. Smart move, strategic restraint, or missed opportunity to tighten control? What do you think? Should bond have been increased given those allegations? This case is far from over, and when preliminary exam hits, that's where the real fireworks usually begin.
That there are punches to the face of officers? I mean, Ms. Gaines, I don't get it.
I understand what you're saying, and I'm saying I did not see any punches to the face when I observed the video.
Well, tell you what, I'm certainly not changing any conditions. Can you explain to me one reason why I shouldn't raise his bond?
Your Honor, he has appeared for every court date, and he has not picked up any new charges. He has not had any contact with the complainant on the domestic violence or any of the officers. My understanding from him is that he has only come to Washtenaw County for court. He does not even reside in this county. It does not appear he's a flight risk, nor that he is a danger to the community. He is here with his father. He has come to every court date, and he's highly responsive to my calls and texts. And absent the no offer in this matter, we'd be looking to resolve it.
Anything else from the people?
No, Your Honor.
You know what? I'm not changing his condition in the bond. I'm not at this juncture going to up his bond either, although of rights I should. Of rights, I don't think he should be out around tethered or not, given that behavior. But I'll let Judge Perry deal with that after she hears the preliminary examination. Bond will continue. Motion for bond reduction or changing condition is denied.
Thank you.